So we're just going to move right into, I'd like to welcome Evie Place. She is, her training is in anthropology, and she presently is with the Faculty of Education through the Mi'kmaq Holistic Way Center. And she's going to do the introductions of our guest speakers for this morning. Evie?
Thanks. I always feel a little short in front of these podiums. We have two excellent speakers this morning, and we have very little time, so I won't spend too long introducing them. But I have promised them 20 minutes each, and I hope we have 5 minutes for discussion at the end of that. And my guess is that lunch is not going anywhere. So if you have questions at the end, hang around and ask them. First speaker is Noel Lyon. He's received his university education at Royal Roads Military College, the University of British Columbia, and Yale, where he trained in law. He taught at the University of British Columbia, at McGill, and at Queen's, and he taught Aboriginal courses and Aboriginal issues there. Later, he was heavily influenced by working with the Mohawk people of Akwesasne. And after his retirement, he has gone on to learn a great deal more about First Nations issues across Canada. Now, I think the suggestion was that I introduce both now and give them the floor. Our second speaker, who will come up after Dr. Lyon, is Renée Pelletier, who is trained as a lawyer and works with Osius Clear Townsend as a managing partner. Renée is Maliseet. Her practice includes work on Aboriginal and treaty rights negotiations and litigation and specific claims. She also has litigated judicial review applications on child welfare matters. She has appeared before courts on motions, trials, and appeals, so she's a well-experienced, active lawyer. Renée has recently cited by the Supreme Court of Canada in the high-profile case of R.V. Pelletier in 2012. Renée advises First Nations and Aboriginal organizations on reserve land management and the impacts and benefits of agreements. Renée has been a working member of a number of Maliseet communities over the past few years on a variety of files. This work has included advice on resource development, including environmental impact assessments at the provincial and federal levels, negotiations with both provincial and federal governments towards full and robust consultation and accommodation process, as well as negotiations with proponents. So that's a huge portfolio, and it's fundamental to the changing nature of our relationships in this country. Her first language is French. She is fluently bilingual in both French and English. Renée is a member of the Indigenous Bar Association and is called to the bar in both Ontario and New Brunswick. As I said, excellent speakers. Hopefully we will have plenty of time to listen and to ask questions. No.
When Ian discovered that I'm living in this part of the world, he invited me over, and I think as a courtesy to an old warhorse who's been out to pasture for a few years, he jammed me into the program. I don't have anything new to add to what's been said. There was a splendid outline given by Bob Ray and by the former Lieutenant Governor. We had a nice follow-up to that. It's kind of the bookends to the proceedings. So what I think I will do is give you a bit of what I have learned over the past 2 days, because that's what I came here for, to listen and to learn. And it's been a long time since I was a participant in the kinds of ceremonies that the First Nations peoples engage in, and the past 2 days have reminded me just how important those ceremonies are to put people in the right frame of mind to deal seriously with serious issues. And I do wish that the dominant culture, of which I'm a part, would take a closer look at these ceremonies for opening and closing serious matters, and for just putting people in the right frame of mind. Our culture, I think, is heavily laden with the adversarial process, and we don't seem to have the capacity to sit down together and talk about things that really matter to us individually and collectively. When Ian asked me what I'd like to talk about, I thought, well, theory is always fun, because over the years I found that there are a lot of people who will say, well, I'm really not interested in theory, I'm a practical person. And a former colleague of mine, the late Bill Letterman, used to say, nothing is quite so practical as theory, as good theory. And he would say, he'd follow that up by saying that we all act on theory, and those of us who think we don't are making a big mistake. We all have theory based on some underlying values and our understanding of the world. So I thought, well, I could have a little fun looking at treaty theory, which is a unique kind of thing, because the Supreme Court has told us that Indian treaties, as we call them, are neither international treaties nor are they mere contracts. So I started off and thought, well, just what are these so-called Indian treaties? So the first step was to say, well, how do we identify treaties? And in the dominant culture, as I'll call it, if you say to someone, well, let's have a look at Treaty 8 or Treaty 11, you go and pick up a document and bring it back. Here's the treaty. And what I've learned, or be reminded of at least, at this gathering, is that a treaty is a relationship. And to think that you can pass off a mere document as a treaty, when all the ceremonial activities that have surrounded the making of the treaty, the revival of the treaty if necessary, and the acting out of the treaty are all a very integral part. So I think as a start, I would say that we should insist on identifying treaties as relationships. The document itself is not unimportant, but it's not the treaty. It's only something that tells us something about the treaty, and as we know, the document may be quite misleading. So I move on to the next stage in my thinking, and I said, well, how do we define an Indian treaty, a native treaty? And I think we would all agree that a treaty is a mutual understanding of rights and relationships as between parties to the treaty. And right there, we're in trouble, because as we all now know, there is no mutual understanding, no shared understanding. And so I think that Bob Ray is quite right. I'm not sure I'd call it renewal of treaties. I think the treaties must be renegotiated, because they were fatally flawed at the outset for reasons that we've been given, that the one party to the treaties did all the homework and did all the follow-up work. Their lawyers picked up the reports and put in language, legal language and English language, what they thought the treaty amounted to. And of course, the people who did that work were acting on behalf of one of the parties to the treaty, and the treaties were just loaded in favor of that one party. So the so-called treaties of surrender, now when I was in law school, I would have looked at that and said, well, that's a treaty, they surrendered their land. But now, over the last decade or two, I've been learning that there was no surrender. It was the lawyers who took these reports of the treaty commissioners in Ottawa and wrote this language in and said, we surrender, cede surrender. Well, like lawyers, they had about 10 different words to embrace the notion of giving up their land. And I think, to me, there's just no question that there was no cession, there was no surrender. And so those treaties that have that language simply have to be renegotiated. And that, I think, is not something that the courts can do for us. I think, we could dream about having a tribunal. It would have to be an impartial tribunal, so it couldn't be a Canadian court, because they are all controlled by the Crown and appointed by the Crown. So we would have to look for some sort of international tribunal, and I would think that it's fair to say that's just not on, because our governments would never agree to that, although the First Nations might. I came up with what I thought was a pictorial representation of why it's so difficult to reach an agreement between parties whose fundamental cultural ideas and practices are so different. Treaties between, say, Britain and France, Britain and Germany, and so on, are relatively easy because their cultural histories are very similar. That was not the case in the case of the First Nations and the Europeans. So I'm a blackboard person. I looked at this and wondered what's happened to my world of education. The blackboards are gone. I do know how to operate. I do know how to operate a computer, but my skills are pretty limited. So I like a blackboard. This is the next best thing. This is all I've got for today. But I think this is a fair representation of European culture. It's a hierarchy. Up at the top here, we have this entity we now call the crown, but originally it was the king or the queen. And originally in English history, the king or queen ruled by divine right. It ruled by virtue of God's gift. That's all gone. Now the British have worked out ways to modernize their constitution and break away from that so that the queen in Parliament doesn't have any direct say in what goes on, but she has to be there, and she has to sign the bills before they become law in Britain. So they worked that out, but if you look at the bureaucracy underneath, first of all, you've got the cabinet right around there, the federal cabinet. So the hierarchy works its way down. You've got the federal bureaucracy, and then you've got the minions, like us, at the bottom. And I think what the British did was they said, well, first of all, let me just offer you what I think is a fair depiction of First Nations societies. Anybody got a suggestion as to what figure might best do it? Absolutely. No question. And what's more, it seems to me this is an ecologically sound portrayal of a community. Now, the Europeans, we've had trouble understanding that we are part of ecosystems. First Nations people have understood that for centuries, that we are integral parts of ecosystems, and that if we want to survive, we have to respect the laws of nature. As Richard Feynman, a famous American physicist, said, nature can't be fooled. And this, I think, is, we've seen attempts by our federal government over the last almost 10 years to fool nature and to pretend you can do things that simply defy the laws of nature and are going to lead to trouble. So, having this as, I think, a more egalitarian arrangement than the hierarchy, because with the hierarchy, you go down through the layers, and then you get to the bottom. And I think the way a federal government lawyer would have depicted this, well, say, okay, sure, it's a circle, but we can put a bunch of circles down here at the bottom, and they derive their power from the Queen in Parliament. And in fact, there was a proposal some years ago that Aboriginal self-government be modeled on municipal law, municipal institutions, which I think is just entirely inappropriate. All that does, because municipal institutions are subordinate to provincial legislatures, and also they're subject to the ultimate final authority of the Crown. Now, just to get back to that for a minute, some of you maybe are too young to remember, but when Pierre Trudeau was trying to repatriate the Constitution with the help of his fellow premiers, the constitutional train went to Ottawa, and the First Nations people tried to stop the train, and they sent a delegation to England, and they went into the English courts, arguing that the British government still had an obligation to the native peoples in Canada, and therefore that they were entitled to be consulted as to what was going to go into the new Constitution. Now, Lord Denning, speaking for the English Court of Appeal, said that all responsibilities, all duties over the First Nations peoples, and he added this, as long as the rivers shall run and so on, It was quite quaint. But what he said was, it's over. We, the British government, transferred all of its responsibilities. Now, you have to think about that for a minute. What were the consultations with the First Nations? How was their consent obtained? They weren't even consulted. There was no consent. So move ahead to the Sparrow case in Supreme Court of Canada concerning Section 35 of the 1982 Act. And the late Chief Justice Dixon, one of our great judges, said in the course of his argument, there was never any question as to the Crown's sovereignty. And I thought about that, and I said, well, never any question in whose minds? And there was never any question in the minds of the dominant society and its lawyers. So the thing was essentially a fraud. It was a set of loaded dice. And if you'd asked the First Nations peoples at that time, have you ever had any doubt as to the Crown's sovereignty? They would have said, no, not doubt, certainty. We knew that the Crown was not sovereign, but they had, well, I was tempted the other day when a woman said, how long are we going to have to go on doing this over and over again to have our communities restored? And my glib answer to the question, why can't it happen now? My glib answer is if you attempt to assert your sovereignty as First Nations in the way it's done in various places, that will bring in helicopters with dogs and guns and the rest of it. That's the only answer, I think, that makes any sense. The power is there. And blockades go up and that kind of thing, and you see riot squads appearing. So I think that we have a lot of unsavory history to turn back and move in a new direction. I guess the only other thing that I want to say, and it's just a restatement of what's been said over and over again, not just here but in other places, is that the heart of the problem is education. Not only has the dominant society remained ignorant, but governments have made it plain that the First Nations people and the general population were not going to know the truth about Canadian history. Incidentally, anybody who wants the truth about British Native relations over the years, I think the best account of that is Bruce Clark's book, Native Liberty, Crown Sovereignty. In fact, when he was stonewalled trying to put this thesis into court, this is a thesis he wrote for his doctoral, his philosophy of, his doctoral PhD at Aberdeen University in Britain. He then came back and tried to put it into effect, and his tactics were upsetting to the judiciary. He ended up being disbarred. He was kicked out of the legal profession. But I think what he was essentially doing was trying to tell the truth to the powerful. And when it comes to the Crown, you can't do that. The Crown cannot be educated. The Crown cannot be told what to do. And I think that's a legacy of empire that we should get rid of, because although everybody, any decent person knows it's just a fiction, the Queen is there only in formality. Nevertheless, governments over the years, over the decades, have abused their status as being the Crown and right of Canada, the Crown and right of New Brunswick, and that kind of thing. So I think that we somehow have to get away from the old assumption that the British Crown had the right to come here, plant the flag, and then establish courts that would not allow the original inhabitants to take their cases to court. There's a funny story. I don't know whether it's true, but it's kind of revealing on this issue. The story is that an Aborigine from Australia had himself dropped in a rowboat in the English Channel, and he went ashore, rowed ashore, climbed out of his boat, and he planted a flag, and he said, "I claim this island on behalf of the Australian Aboriginal people. And, it's a joke. The whole thing is a joke, and I think it's time we stop being polite with the people who continue to ride on this joke and get down to the serious business of renegotiating our relationship as one between equals. The equals being, in one case, the settlers in Canada, and the other being the First Nations.
Please hold on to your questions. We'll listen to Renée next. Thank you very much.
Thank you. All right. So I'd first like to just take a minute to recognize the elders, chiefs, community members who are here at the conference today, and also thank the conference organizers for inviting me to speak. It really is an honor to be here. I'm conscious of time and that I will be standing in the way of all of you and food, so I'm going to try to make this quick. So this topic is something that I'm very passionate about. As an Aboriginal woman practicing Canadian law, I often feel that I have kind of a foot in two worlds. And people will often ask me to describe my practice and say, oh, you practice Aboriginal law. But let's be clear, I don't practice Aboriginal law. I practice Canadian law as it applies to Aboriginal people. And as an Aboriginal woman, I often find that practice quite frustrating. And I think the topic reframing Canadian law to promote reconciliation kind of speaks to part of the problem. This idea that settler law or Canadian law reigns supreme and should reign supreme in our country. And I think Noel's presentation really well laid out some of the erroneous assumptions behind that. And I think we really need to challenge those assumptions. Oh my God, I can't work PowerPoint. Here we go. So in this presentation, I'll be talking about reconciliation in the context of the Peace and Friendship Treaties and the idea that this requires us to relinquish interpretations of law that do not acknowledge the equivalency of Indigenous legal traditions. So this is really the golden thread of my presentation, that Canadian law in its current form has become ill-suited to achieving the goal of reconciliation. That recognition of Canada's legal plurality and Indigenous laws for Indigenous peoples is the answer to the reconciliation question. Now, of course, because reframing law in Canada to recognize Indigenous legal traditions would be undoubtedly the high watermark towards achieving reconciliation, I'll also very briefly discuss some of the ways that the current legal system could take steps on the path towards this ideal. So I want to begin by taking a moment to discuss the term reconciliation. So reconciliation as a legal term and theoretical concept has been widely used by Canadian courts and federal and provincial governments. But it's important to be clear what exactly it is that we're talking about. What does reconciliation mean? And to whom does it have that meaning? What interests are being reconciled, and whose interest does reconciliation serve? There are many definitions of reconciliation that have been articulated. Black's Law Dictionary defines reconciliation as the restoration of harmony between persons or things that had been in conflict. In my view, this definition leaves something to be desired. It speaks more to the desired outcome of reconciliation, but not to the how of reconciliation. So if you look at the roots of the word reconciliation, we see notions of reestablishment and renewal. And some interpret the Latin roots of reconciliation to mean sit again with. And others have said that reconciliation begins by agreeing to sit under the same tree with your enemy, to find a way of addressing the causes of conflict. So I propose to use this understanding of the term reconciliation, coming back to sit at the table together or under the same tree. Now, sadly, this notion of coming together as equals is largely not happening in the current Canadian legal system. And as I move through my presentation, I'd invite you to think of your own examples of ways that the Canadian legal system requires Aboriginal people to sit under the Canadian legal system tree, and think about whether that's been working at promoting reconciliation. The answer is no, it has not been working. So John Burroughs, who is a leading Indigenous legal scholar and someone that I've had the privilege of working with, notes that Canada is a legally pluralistic country where common law, civil law, and Indigenous legal traditions all exist. Legal pluralism means the simultaneous existence within a single legal order of different rules applying to identical situations. For Mr. Burroughs, Canada's current legal system is incomplete to the extent that it does not acknowledge Indigenous legal traditions. His position being that we must recognize Indigenous legal traditions as giving rise to jurisdictional rights and obligations in our land. I'm going to echo this call to action today in my discussion on how we might reframe the law in Canada to promote reconciliation, specifically in the context of peace and friendship treaties. So there are many ways to define the purposes of law and the legal system. Dr. Val Napoleon notes that in its best form, the way to think about law that's helpful is that it enables human dignity and agency and provides ways for people to challenge internal oppressions and internal power dynamics. Now, if we take this understanding of law as something that should enable human dignity and provide agency to people to challenge oppression, it's clear that Canadian law has not done these things for Indigenous people. Trying to make Aboriginal issues fit into Euro-Canadian legal compartments has resulted in lengthy, costly disputes that often fall short of achieving the desired outcome. When there are victories in the courts, decisions are often later clarified or refined to be more restrictive or narrow in their application. So one example that we're all familiar with, of course, is the example of Marshall I, where the Supreme Court, in interpreting the Truckhouse Clause, found in some peace and friendship treaties, found that Marshall, as a Mi'kmaq person, had the right to catch and sell eel subject to the limitations of livelihood rather than open-ended wealth accumulation. But later, Marshall II, the Supreme Court clarified that the Truckhouse Clause gave a right only to continue trade in items traditionally traded in 1760 and 1761, what the court called the trading activities that were in the contemplation of the parties at the time of the treaties. Another example of how Canadian law has become ill-equipped to properly address Aboriginal matters is the long history of case law dealing with Aboriginal title. Now, Aboriginal title, when articulated through the common law system, is equated with fee simple, which, as we know, is, you own it. Like, that's kind of as good as it gets. However, when applied in the Aboriginal context, the courts have really given it no teeth. Where Aboriginal title is found to exist, the community is entitled to exclusive occupation, but it is subject to the possibility that the Crown can show that its infringement of the title lands is justified. Another example is found in fiduciary law. A long history of case law demonstrates that courts were unsettled on how to properly classify the legal relationship between the Crown and Canada's Indigenous people. In Guerin, the Supreme Court of Canada spoke of this relationship as a fiduciary one. Now, fiduciary law as a common law Euro-Canadian legal concept has been described by some courts as the highest duty in law, to act altruistically for the sole benefit of the beneficiary to the fiduciary's own detriment if necessary. However, when applied in the Aboriginal context, the courts have held that it's not really a fiduciary relationship. Of course, in order to find that there's a fiduciary relationship in the Crown Aboriginal context, there must be a source imposing an obligation upon the Crown to act for their benefit, i.e. an agreement, undertaking, or statute which would impose this duty. And this, of course, really limits the ability of Aboriginal peoples to, use arguments of the fiduciary, of fiduciary law and the fiduciary relationship, and it's really limited only to specific circumstances. Later in my presentation, I'll touch on a few more examples of areas of the Canadian legal system that have not historically and do not currently promote reconciliation, and provide some suggestions for how these areas could be reframed. So in the context of Crown Aboriginal relations, particularly in peace and friendship treaty nations, the idea of reconciliation as a reestablishment and renewal of past relationships is particularly important. For reconciliation to occur, all parties must come back to sit at the table together. For meaningful change for Aboriginal peoples, reconciliation cannot be about surrender. Coming back to the table together, or sitting under the same tree together, in the context of the peace and friendship treaties, must be about honoring the original intention of the parties, recognizing that they can be seen as the creation, treaties that is, can be seen as the creation of an intersocietal framework in which first laws intermingle with inferior laws to foster peace and order across communities. So as we are all aware, peace and friendship treaties are silent on extinguishment and surrenders. First Nations did not give up legal rights to land or resources in these treaties. Title to Aboriginal lands was never surrendered in any treaty process. Treaties recognize Indigenous peoples' right to make decisions in accordance with their laws, and Indigenous peoples are not the only beneficiaries under treaties. And yet the silences of the peace and friendship treaties have been filled with Canadian law. So when we're trying to deal with an issue that is not explicitly covered by a treaty, or when trying to interpret ambiguities in a treaty, courts of the Crown look to Canadian legal principles to fill those silences, not to Indigenous legal principles. So for example, we think of consent for development or resource exploitation is rarely considered necessary by the Crown in the context of a treaty relationship. So for me, reframing Canadian law to promote reconciliation means acknowledging that Canada is a country of legal pluralism. That is not to say that Canadian law and Indigenous legal traditions are in competition with one another, but that they both exist side by side. They are both legitimate and equal. Reconciliation in light of the peace and friendship treaties could be furthered by the Crown and Aboriginal communities coming back to the table to acknowledge that Indigenous legal traditions were never extinguished by the peace and friendship treaties. The silences of these treaties should be filled with the laws of the people of the communities who signed them. Mr. Burrows describes the importance of situating Indigenous legal traditions in the present day, writing that they can constantly be recast to show us how to appropriately channel and cope with conflict, and continually reformulated to show us how to create a stronger order. I would argue that the same view can be taken of the peace and friendship treaties. These treaties are not relevant only from a historical perspective of Crown Aboriginal relations from 1725 to 1799, but rather they show us the original intention and understanding between the signatories, and they must be recast over and over in light of modern-day conflicts and struggles to remind us that rights, title, and Indigenous legal traditions have not been extinguished. These rights are alive, and they are the answer to the reconciliation question. This means, I think, as an ideal, self-government, self-definition, and self-regulation. Now, while recognizing that Indigenous legal traditions for peace and friendship treaties, I'm supposed to switch slides. There we go. While recognizing the recognition of Indigenous legal traditions for peace and friendship treaty nations on the basis that rights to land and resources were never surrendered through any treaty process is the goal, I want to speak very quickly about some of the steps that could be taken to reframe Canadian law presently with a view of achieving this goal and promoting reconciliation right now. The first is Canada's comprehensive claim policy. There has recently been a report called the AFERD report, which was an independent report that made recommendations about ways in which Canada should be reframing its policy. And one of the criticisms of the specific claims policy is that Aboriginal groups, the existence of an Aboriginal group-specific Section 35 rights are not recognized at the outset of negotiations. And this approach, in my view, cannot promote reconciliation. And the AFERD report recommends that Canada should develop an alternative approach for modern treaty negotiations, one informed by the recognition of existing Aboriginal rights, including title, where title can be conclusively demonstrated. So developing such an approach, which has been recommended, could be one way that the current legal system could start to promote reconciliation today. Another example is a look at the way English law deals with sacred spaces. A colleague of mine, Senwan Luck, wrote a paper in the Supreme Court Law Review where he discusses the conflicts that arise between Indigenous and non-Indigenous people in Canada over sacred spaces and sites. And he looks to how English law, which is kind of the source of our common law, how English law deals with sacred sites. And he notes that in England, it is the Church of England and the Church's law that basically govern how a site is going to be used, developed, etc. And if the government wants to develop, say, a burial site, it must first get permission from the Church. So Senmon asks, what would it look like if the Canadian state treated sacred sites in Canada the same way that the state of England treats English sites? If it treated Indigenous law about the sacred the same way that English law approaches English law about the sacred, achieving this goal would require many areas of the Canadian law to be reframed. But it would be a system that better respects the Indigenous sacred spaces and sites, and I think would do much to promote reconciliation. The other example is in Nunavut. So this is an example where there's an integration of Indigenous legal traditions into the Canadian legal system. And so in Nunavut, the Inuit are implementing their legal traditions in the contemporary Canadian legal context as a result of their land claim agreement and their powers of public governance. So one example is discussed in Constance McIntosh's chapter in the recently published Canadian Perspectives on Animals and the Law, called Indigenous Rights and Relations with Animals, Seeing Beyond Canadian Law. And in her chapter, McIntosh describes Nunavut's decision to codify the Inuit understanding of human-animal relationships in their Wildlife Act. So it's a process that required incorporating Inuit terminology so as to embrace Inuit knowledge of human-animal relationships. So the act actually codifies elements of Inuit laws and beliefs, which also guide the interpretation of the act. So in closing, I just want to say that sometimes in my practice, I get so angry at all the obstacles that Canadian law places on Aboriginal people. The amount of money that communities have to spend and the legal hurdles that they have to overcome to prove things like Aboriginal rights and title. To prove things that they've known all along that they have. And sometimes I get so angry at the imposition of Canadian law on Aboriginal people that I think, you know what? We were here first. And our laws are the ones that should apply, and you, Canadian government, should come to us and seek permission to do things. But then, after I've calmed down, I remember what the peace and friendship treaties actually stand for. And I think of a lot of what's been said here at this conference. And I think of David Purley's words on Wednesday night about how the treaties were an invitation for the settlers to become a part of our family. So if we're going to find a way to act like brothers and sisters, then we have to find a way to respect our respective legal systems and traditions and find a way for them to coexist, but to coexist on equal footing. And what that looks like is not something that I can answer, nor is it something the government can answer or draw up a policy or framework for. It is something that needs to come from the Aboriginal communities themselves. Lyon.
Start, the government should ask the First Nations, what do you think we should do? They've never done that. They've always said, here's what you're going to do. What do you recommend? Should we gather all these people together and make a treaty with a lot of them and escape the limitations of the particular territories and people who were dealt with individually over the years? And that's one possibility. But I think for a start, our governments have to start listening to Aboriginal peoples.
Yeah, and just to add to that, that's exactly my view as well. You know, in a lot of my work, represent communities where sometimes there's overlapping claims with other communities, for example. And, you know, chiefs of council will come to me and say, well, you know, how do we deal with this? And the first thing that I say is, like, that's not something I can answer for you. It's not up for me to decide. This is, you know, nation-to-nation relationships, and you need to, you know, to speak with your, you know, fellow nations and come to an agreement yourselves. And it's not something I think that, as a lawyer, that I would ever want to give advice on.
Oh, another question?
Yeah, in light of the topic dealing with legal traditions, I'm wondering what your remarks are, both of you, with regard to the only statutory recognition of an Aboriginal legal tradition and customary law framework, which is the Canadian Human Rights Act. When it repealed the exemption for the Indian Act, it replaced it with a clause, an interpretive clause, saying the tribunal has to take into account First Nation legal traditions and customary laws. Remarks on that in terms of a way forward in terms of reconciliation. It seems to me it's the only statutory provision that does this in Canadian law.
Sure, no, and I think that's, you know, I should have actually listed that as one of the examples in the way, you know, the ideal is to have this system in Canada that recognizes the different legal traditions. That is the ideal in my view. Until we get to that place, I think, you know, as I mentioned, there are things that can happen within the current system. That would certainly be one example, and I think we need to see more of that. You know, I'm not, as much as I do a lot of litigation, I will often tell my clients that it really should be the last resort because it's so expensive. But, you know, another one of the things that I like to try to do in my practice is to bring Indigenous law and customs and traditions into the litigation context and use those things as evidence for things like title, which is kind of another way of getting those kinds of concepts incorporated into Canadian law. So I'd love to see more of that until we get to this wonderful day where Indigenous law is recognized.
I think we have a problem because we've lived so long in a world in which the Crown calls the shots, initially and finally, that it's hard for us to wrap our minds around the concept that you consult with First Nations and ask what they think is a good thing to do, which I'm just repeating myself, sorry.
Imelda?
First of all, I want to give gratitude for what the city members and we have been in front of all of us as witnesses. And one of the things that I'm hoping, I'm so proud of you as a young officer in the West of the woman, to be bearing those moccasins in the community. But I'm hoping that one of the biggest issues in all of those reconciliation is
thank you for that. I think that exactly sort of puts the finger on how it is that the Canadian legal system is ill-suited to deal with our issues. There was the case Delgamuc that talks about, oral traditional evidence should be given the same kind of weight. I can tell you that I have run trials where it is not given the same kind of weight, and, opposing counsel stands up and argues that's hearsay, and then there's these kind of exceptions to the hearsay rule that let parts of it in, but like the standard of proof is ridiculous. The legal concepts are so totally different, and again, it's this example of trying to fit this Aboriginal concept and into this Canadian legal framework that just doesn't work. So that's what we're stuck with for now, and I think that, as lawyers practicing in this field, we do the best that we can. And I'm happy to chat later about some creative ways that I've come up with to try to bring the Indigenous perspective into Canadian courts, but no, it's not ideal.
Looking at the court cases that seem to go through the Canadian courts, it seems like the Canadian taxpayer spends a hell of a lot of money to fight these native cases. And it seems to me like under this peace and friendship, that it should come together under this country, and we should stop the waste of so much money. And a way to do so would be to hold fiduciary responsibility to those who bring in those judgments, those judges. So when a judge brings in a statement, like in the Jacoby case, that is, of course, in favor of the Indigenous people, but stops short of implementing. I do see that the Indigenous cases are getting a more favorable treatment in the court system, but what I don't see is when those decisions come out, that those decisions hold true to what it says. What I notice is we need to get rid of commas. We need to dot I's, cross T's, and add periods, because the interpretation of a sentence is very clear. But the interpretation of something that is put together as a collage with commas is not clear. And we spend more money fighting those cases. So in the legal sense, or in the legal realm, how do we hold those who render those decisions fiduciary responsible to bring out a decision that moves forward without the wastefulness of the court's time and the money it takes from taxpayers to do so?
Well, it's a mixture of the last question and this one. I think that as long as we try to get the oral evidence out within the context of the adversary system with examination and cross-examination, it's doomed. I think what I would advocate is to put, whether it's judges, ministers, bureaucrats, or whoever, put them in this kind of context, go through the smudge and the rest of it, and then call on the bearers of oral history to give their account of what that oral history is, keep the lawyers out and say there's not going to be cross-examination here, these people tell the truth.
No, I think that's totally right. And, if you look at Chilcotin, I'm glad you raised that, Russ, because that's a perfect example. That was groundbreaking. It's the first declaration of Aboriginal title in Canada's history. What does it mean? It's not like the Chilcotin people got a ton of cash and now they're setting up their government. They've got Aboriginal title, and there's all of this stuff going on within their territory that they've now got to sit down and negotiate with the government about. And, so it's all of these uncertainties. Even after a victory, it feels a bit empty in a lot of ways.
It does feel like a victory because we did hear the ruling, but in actuality, it's a battle won, it's not a war.
Yeah.
Because the decision that came out was though they won a large portion of the area they were trying to protect, it is a small equivalent of their entire territory.
That's right.
So when people kind of got the smile on their faces, oh my God, they got title to their territory, they did not.
Tell this much.
They got title to your backyard. You still don't have title to your front yard. So that's, so it was a great
Thank you for that comment. That's excellent.
I think we can give another,
I just have a comment. Is it Noel?
Yes.
I appreciate that you're saying that education is the key. I'm an Indigenous Affairs coordinator from Nelson University, and in Nova Scotia, on Treaty Day, the Tri-Party passed a document that every teacher in every classroom, K to 12, now have to include Indigenous knowledge in the curriculum. Being the lone person in my program at Mount Allison University, I also speak and lecture for professors on Indigenous issues. And a professor came to me and he said, "You really got my students riled up." Because I tell them that they need to go to their government, they need to write letters, and they need to get mad because they didn't get a very good education. And it's for their children in the P to 12 that need that education. So I say, get mad, write those letters to your MLAs, write to the government, demand that your children get a better education. And he said, well, you get my students riled up. I said, well, that's okay. I said, if you don't see smoke signals, don't worry.
Let me just add a
I just wanted to add a comment kind of to both of you. In terms of different legal systems, I think there needs to be an understanding too of how the British and European legal systems developed in Europe as well, and how kind of the lower classes of Europe had to be suppressed as well. Their traditional knowledge had to be also suppressed, and it's really north of these legal systems as well. But when that was applied here in Canada, it's the same thing. We have Canadian people being suppressed as well. So I think the legal system, the dominant legal system we have now, and I think, well, in terms of kind of the history of, game laws in Britain and France are an example of that. The idea of indentured servitude, that the settlers coming over here and having the laws, they were also suppressed to all of the Canadian things. And even development of capitalism. So there's larger kind of systems and contexts that we have to also understand. And I think we have to understand that there's really a common battle that we have as Canadians to fight the legal system that's not really meant to protect us. And yet you have policing individuals do so. I just want to make that.
No, that's an excellent comment. Thank you, Mario. That was great.
did you want to respond? You had something to say?
I just want to add something to what was said over here a minute ago. I think as part of the process of getting our population properly educated, I think it would be important, this is based on my own experience, to give an opportunity to teachers and others involved in education to experience this kind of gathering. Because I
gonna be
think
online,
it
right?
has an enormous impact.
There were two more people. The lady at the very back first, Jamie second. I think we should. How's food? Is it here?
Yes.
Okay, that's the last two. Thank you.